This legislation makes 4 basic reforms to the judicial foreclosure process in Florida. For the benefit of the borrower, the legislation shortens the statute of limitations for deficiency judgments to 1 year. The bill places an affirmative duty on lenders to produce the mortgage note or provide sworn evidence that they are the owners of the note, eliminating fraud and other problems that resulted from the robo-signing practices of the past. Legislation provides certainty and protection to a good faith purchaser who acquires property after the final judgment of foreclosure. Any party to the action, any lien holder, and it could be the lender, it could be the second mortgage holder, it could be a homeowner or condo owner association, could move the court to hold a show cause hearing. Basically to ask the court to determine whether or not there's a justiciable issue, and if there isn't, to enter the judgment in foreclosure.
The hearing could be conducted prior to any discovery, is that right?
It's conceivable. This show cause hearing is for the borrower or the defendant to advise the court that they do have a valid defense. For example, something like, I didn't sign the note. Or what is probably more likely these days, the lender did not afford me the opportunity to modify the loan as required by federal law. Now, if the borrower says something to the effect that, Judge, I owe the money, but I really don't want to move out, that's the kind of thing that we're hoping to handle in the show cause provision.
Many of the defenses or counterclaims, a defendant might have, like issues related to robo-signing or potential fraud. If someone had not conducted discovery, they probably would not be able to meet this standard. And so if, for example, someone doesn't even realize that robo-signing has happened, they're not permitted to conduct discovery, is it foreseeable that this show cause hearing could dispose of the case before the defendant even knows that they have that potential defense or counterclaim?
Well, frankly, I don't believe that the robo-signing issue would be a defense to non-payment of a mortgage debt. The borrower's defenses are ones that are a defense to a foreclosure of a failure to pay a debt. And they would be things like, I didn't sign the note. Well, frankly, I don't believe that the robo-signing issue would be a defense to non-payment of a mortgage debt. I didn't sign the note. Robo-signing, I didn't sign the note. Robo-signing doesn't affect the actual payment of the debt. I didn't sign the note. The Supreme Court's process is actually trumped by the law. It is not the owner of the mortgage, it is the holder of the note that is the only party entitled to foreclose, because that is evidence of the debt. The note is the evidence of the debt. So whoever holds that note is the party entitled to foreclose it. There are a lot of abandoned houses where the lender does not want to take title and just sits on the foreclosure, and the condo and homeowner associations are just waiting.
In a lot of instances, there's renters who are renting properties who have no idea that the owner of the property is in foreclosure, and so the renter is paying his or her rent, and one day somebody shows up and says, basically, get out. Are there any protections for renters in this bill at all?
We don't address that in this bill, but there is a bill that, I'm not sure, I think it might have been Representative Morita. Somebody's got a bill floating around that requires in a landlord-tenant situation, if the property is in foreclosure, I think that may have been Rep. Porter's, there has to be a notification that the property is in foreclosure in the lease.
14 mortgage servicers have entered into consent orders with the government after a review of their foreclosure process found many violations, including mortgage balances at the time of foreclosure action, were more than the amount actually owed by the borrower. The borrower was current on paying a loan modification, but the foreclosure took place anyway. The foreclosure went forward even though the borrower was protected by the bankruptcy, or the fees charged in the mortgage payments were inaccurate, calculated, processed, or applied.
We know there's a fraud issue. I mean, that's clear. There's been a lot of fraud as relates to foreclosures. But what about the first party? What about the first party that was frauded out of their home, that was mistreated? What about those folks? We're saying we don't want to kick a family out who bought the house not knowing. What about the family that was kicked out of their house illegally?
The point that you're missing here, however, is that if the borrower could unwind the whole transaction and take the property back, what are they going to get back? They're going to get back a house that's underwater with a mortgage that's more than the house is worth. They're not going to get it back for free. They're going to owe a ton of money. And it could have been, we're talking about somebody that hasn't paid since 2008, for example. There's going to be so much money owed, they'll never pay it back.
The purchase of a home is the most significant financial investment we'll ever make. It's also where we raise our kids, and I think we have to be extremely careful. And with regulating foreclosure, many of these provisions go too far. The show cause proceeding that we were discussing on Friday certainly goes too far in curtailing the rights of homeowners, as do provisions relating to the rights of persons who potentially have been defrauded. So I urge you to vote down on this bill. Thank you.
In light of the bank's conduct over the last many years through this process, in line with the show cause procedure that I have issues with, I think the last thing we need to do is speed up the foreclosure process through this bill. If we want to add more money to the budget for the court so that they can address this issue in a judicial process, then I would be in support of that.
You're talking about a provision in this bill that essentially denies somebody who suffers a foreclosure as a result of fraudulent claim, fraudulent documentation. They would lose the right to recoup their home. We've had a major slowdown as a result of a particular attorney who ran the largest foreclosure mill in the state, and he was forced to close his doors in 2011 after a multitude of fraud allegations surfaced, and so that put the brakes on the whole foreclosure process. There's money coming into the process from the Attorney General, hundreds of millions of dollars to help deal with this issue. I think we probably will do better.
Florida's number one. Florida's number one in foreclosures. That is not a distinction that we wish to have. Members, until we do something regarding the foreclosure issue in this state, lenders will continue to be hurt, borrowers will continue to be hurt, and the economy of the state of Florida will continue to be hurt.
Some of the concerns that have been mentioned, that some families who don't understand this process may walk out of a hearing without fully knowing what happened, without even having that moment in time that they need to be able to fully explore what happened to them and how they may have been disadvantaged by a bank.
I'm concerned about the buyers who this might have been their first home, their dream home, and now they're losing that property, and they need time to get from under this. And let's put the settlement money back into our communities so that we can help everyone.
I'm a member of the home building industry, and like Representative Rogers stated, the foreclosure process has hurt a lot of people. But you have to understand the other people that are out there that live in the neighborhoods where the foreclosures are taking place. You have good, hard-working people that have struggled to make their payments every month. And because the foreclosure process is such a long process, you have dilapidated buildings, yards that aren't being kept up, and you have these people that have worked very, very hard to make payments in tough times, suffering because of the long foreclosure process.
The public interest is served by maintaining the strong tradition of judicial due process in mortgage foreclosure cases. But the mortgage foreclosure cases need to be moved along to final resolution expeditiously in order to get the property back into the stream of commerce.